Happy to do it, Jess. Welcome, everyone. This is about the Americans with Disabilities Act, and we're going to focus on employment because that's the part probably that impacts all of us. But bit of context how I got involved in this thing. Back in 2012 or so, I was in another department and I was dealing with a situation. And by the way, back in 2012, there was a whole different cast in HR. It's totally different now, so I'm not talking about anyone that's currently there. But I was thinking about asking for an ADA accommodation. I thought about it for 2 years, and it was related to a mental health condition. And I'm sure, like many people, you didn't want to be known as as a broken little toy, or that something was wrong with you. So I avoided it and didn't know what to do. But the situation got such that I just had to ask for my basic human rights under the ADA. Now, I fully expected that HR would be knowledgeable about the ADA process and that they'd adhere to the law and that they would be fair and impartial and I would be treated fairly. But I was wrong on all those counts, so I'm a little bit jaded. Thus said, the people there are very good now. But I had to go through a fairly invasive process with HR and fight to get some basic accommodations. HR ended up outing me to my department. I didn't want people to know I had this condition, but they did. They disclosed my condition. And back then, when I became upset, essentially they said I should get over that. So a basic accommodation was put in place, but it wasn't followed. And then 3 years ago, I got a call from HR, and the person on the phone told me I had to go through this very invasive and humiliating process of asking for an accommodation again. And I found out my supervisor was discussing my condition with colleagues, and that's not right. So fast forward to today, we've been working with HR to put a better process in place so that other people don't have to go through this. There's still some bugs in the system, but we're getting a lot of them out. The American with Disabilities Act is a law that was put in place that prohibits discrimination against individuals with disabilities in all areas of public life. And this was put in place in 1990. And it's designed to ensure and protect the civil rights of individuals with disabilities. And this is a civil right. A civil right. There's 5 parts of it. We're going to focus on Title I, but we should be aware of all parts of them. Title I prohibits discrimination in all aspects of employment, and this will be the focus here. This has to do with getting accommodations put in place so that you can do your job. Title II ensures that people with disabilities can fully participate in all aspects of civic life, and it prohibits discrimination in providing public services and programs and activities. Transportation, accessibility, playgrounds, etc. And why do I have the MAV pods up there? And this is my wife right there, Nancy Fitzsimmons. When they were put in place, people with disabilities could not get into these. So they were violating ADA accommodations, and some of us got a little upset. And you can imagine if you're a person in a wheelchair coming to campus and you see these things, and essentially it says to you, these are not for you. These are not for you. They didn't even think these were wonderful things. So my wife filed a complaint, and what they did, what the campus did, is they got up, they meet the very basic minimum of the conditions for ADA, and they found other accessibility spaces. So if you're in Armstrong Hall, if you go to the library, well, then you can have access to this, or Trafton Hall, or whatever. Now, could you imagine If you're at a football game and you wanted to use the restroom and they said, well, this isn't accessible, you have to go to the other side of the field and use that one. Well, if you have a disability, that is essentially what they're saying here. They put this little sticker on to meet just the basics. And I thought, I'm a little cynical. This was interesting. They help with my ADA plus are comfortable and quiet. They're putting kind of a disability there to give the sense that, yes, we are compliant. Well, they're just basically compliant. And when I brought this up, they kept coming back with, well, they are used all the time. And it's not about how many people use them. It's always about how many people can't use them. And if one person can't use math pods, that's one too many. So we're still not happy with this because they're not easily accessible to all people. And then there's the situation with Val and my wife. I'm proud of her. She also came up with this, fought for Val's rights here. A fire drill. She's on the second floor. She was told, if there's a fire drill, go to this place, call security, they'll come and get you. Well, she followed it. There was a fire drill. She went to that place. Security didn't come and get her. And when she finally brought it up, she was kind of mansplained away. She was not taken seriously. And it wasn't until she went to the student government and that was videotaped and spread around that her complaints were taken seriously. Title II has to do with private businesses. Ensure that people with disabilities can, 3, new construction modifications must be accessible to individuals with disabilities. For existing facilities, barriers to service must be removed so that it is easily accessible. Public accommodations. And here's things we don't think about. Well, in a bathroom situation or a desk, if you're in a wheelchair, it needs to be closed. These are things we don't even think about. Desks, we don't even think about. Wheelchairs, can they get through the bookshelves in the library? Things we don't think about. And by the way, they can. I checked that out. What is the minimum distance between things? These are things we don't even think about. Now, a couple years ago, there was a restaurant, Neighbors. It's down there, but it's not a restaurant anymore. And it was pointed out that their restrooms or something wasn't accessible. And they put up a big stink. Why do we have to pay all this money and do all this? And here's the thing. This has been the law of the land since 1990. It's the law. It's the law. You either follow the law or you don't. You can't just follow part of the law. Title IV has to do with telecommunications and with technology. This is pretty good today with all the technology. And Title V is the miscellaneous provisions, and that covers things like insurance, coverage, recovery, no coercion, no retaliation, sorts of things. That's the miscellaneous. So let's look at Title I, employment. What does it say? If you have a business with 15 or more employees, you must provide equal employment opportunities for individuals with disabilities. What does this mean? Well, first of all, the hiring process. Posting, interviewing, job offers, and hiring. And just brought up last year, when we put out our hiring practices, our calls for people, are we putting in that application? People with disabilities are encouraged to apply. Do they know if they have a disability? If they come on campus for an interview, will things be accessible for them? The hiring process, that's the first part. It requires employees to make necessary reasonable accommodation. Reasonable, and that's subjective. It's open for interpretation, and that's fine. For known disability of a qualified applicant or employee, they must be qualified. unless accommodation would impose an undue hardship. And that, again, is a subjective term open to interpretation, and probably the way it should be. You cannot require pre-employment medical exams or inquiries to determine if a person has a disability. You can't use a selection criteria to screen out individuals with disabilities unless that disability is related to the job. For example, if you're a firefighter, you can't have something as, can you climb a ladder or carry something up a ladder, all right? That you can do. You cannot use a selection to screen out individuals with disabilities unless the criteria is job related. You can't have a general test to see if they have a disability. You can inquire about their ability to do the essential functions of the job. You can do that at any time. Before they're hired, after they're hired, when they're working, at any time you can inquire about their ability to do the job. As professors, your ability to teach, do scholarship, and do services. You can inquire about that anytime. Employers must keep any medical information or the results of medical exams confidential. That is very important, especially if you're dealing with a non-visible disability. So, what is a disability? The ADA defines it as physical, mental impairment that substantially limits one or more major activities. Substantially limits, and let's take a look at them. These are all considered major life activities. Major life activities. And I highlighted the ones in yellow because if you have a mental health condition, a non-visible condition, these are often the life activities that become impaired. Some disabilities are non-visible. All right, include these. You don't see them. And if you have a non-visible disability, mental health condition, you tend not to be given as much credence. Oh, you can't be serious. You're trying to get away with something. Imagine how that feels. If you have a disability and you're looked down on, you get the impression sometimes that they think you're trying to get away with something. How hurtful that can be. Non-visible, related to mental health, as I said, these are all conditions, and mental health conditions include these and more: post-traumatic stress disorder, bipolar-related disorder, depression, anxiety disorders. And with COVID, of course, we all know there's been more cases of these. Disability could be related to a major bodily function. Includes some of these things. And again, these are not all readily apparent. What about drugs? Nope. If you're currently engaging in the illegal use of drugs, you're not qualified under the American with Disabilities Act. All right? You can, the employer, can inquire whether they're casual user or user of drugs. So drugs is not, illegal drugs is not covered under the ADA. Now the heart of the matter, what is a reasonable accommodation? Reasonable accommodations deal with qualified individuals, enable them to do the essential functions of their job. Accommodations must be reasonable and cannot cause undue hardship to the operation of the organization. And again, these are all open to some amount of interpretation. Reasonable accommodation. That's a change in the work environment to help perform the essential functions of the job. Now, this varies with each individual and each job that they have. There's no one standard. Reasonable accommodations. Always open to interpretation, but dependent on the condition. These are just some of them. Reasonable accommodations. And here's the thing about reassignment. The employer does not have to create a new position for you or other employees. You can be transferred, but other employees can't be terminated to make a position vacant for you. And the individual should be qualified to do that new position if there's a reassignment involved. Great resource, Job Accommodation Network. And I'll show you what this is in just a minute, but this is very important. JAN, do a Google search, and you'll come up with this. And they have A to Z of all the possible disabilities. And when I was asking for an accommodation, I went there. And you can plug in or tap into your specific disability. And they'll tell you a little bit about that disability. And this is good to know. Background information. And I'm going to use the case of an anxiety disorder. These are all the things that are impacted if you have an anxiety disorder. Common symptoms of an anxiety disorder. To give you an example. And they give more background. Job Accommodation Network. Employees and questions to consider. All these things. This is the type of information found on the Job Accommodation Network, JAN, an important resource to use. HR now uses this, and they'll give you some ideas on key accommodations, what you can ask for. When I was asking for my accommodation based on a mental health condition, I had no idea what I could ask for, and this gave me some ideas here, as well as situations and solutions. So that is a good resource. And here is the heart of the matter. The process of requesting reasonable accommodations under the ADA. If you have a documented disability, you can request reasonable accommodations. Documented. That means you may have to have medical you may have to get a letter or some sort of documentation. You can't just say, oh, I'm feeling depressed, give me an accommodation. Oh, I have this. No, it has to be documented. Just like our students when they ask for an accommodation. It has to be a documented disability. Now, this is the process that we in the IFO have worked through. Now, here's the thing. We put it in place, and HR last year just kind of ignored it or kicked it out. We're trying to build this trust bridge, and sometimes they come along and they kick all the bricks down. It involves trust. The IFO is available to assist you. And I encourage you, if anyone is thinking about asking for an AD accommodation, contact me or someone in the IFO. I didn't know what to do when I went through this. I had no idea what to do. And you don't have to go through this by yourself. You don't have to go through what I went through. So I would really encourage people, if they're considering this, to contact me or someone in the IFO or someone in the Disability Caucus. They are there to help you, and other people have gone through this. So that's important. When the disability or the need is not obvious, HR may ask for reasonable medical documentation about the impairment and the limitations. And this is a note from your medical health provider. And the documentation should say, yes, this person has that condition, and this is how it affects the essential functions of the job. That's important, essential functions of the job. Do not fill out any forms. HR exists on forms. The world doesn't exist unless there's a form to fill out. And they have 2 forms, and I'll show you this, but you don't have to fill out the forms. Here's one of the forms, and it gives you the impression that you need to fill this out. And this is not just germane to Mankato. Statewide, this form is used, but you don't have to do it. You don't have to fill out this form. All you have to do is notify HR that you are asking for an accommodation. All right? This is interesting. Is this information necessary to determine whether you have a disability? This information may be used by the agency for the purpose of providing reasonable accommodations. This information is necessary to determine if you have a disability. No, it's not necessary. It's not necessary. Your refusal should not make it any harder. They give you the impression that if you refuse to fill out the form, that you may not get your accommodation. And when I was going through this, I was so afraid of not getting the accommodation, and I had no one to account it. I filled out all the forms, and that wasn't good. Is this information strictly voluntary? Yes. Will your refusal no. No. And again, they give the impression. This is taken from the state, MMB, so it's not just germane to Mankato. Now, the medical information release is one that you really shouldn't fill out. And I'll show you why. And again, this is MMB. This isn't just Mankato, but you don't have to fill this out. Here's one. Authorized to speak to my treating healthcare provider directly in regard to any question with respect to my condition as it relates to the essential functions of the job. Oh, really? You're going to sign a statement that says that anybody they designate can contact your doctor and ask, or health provider, and ask any question they want. Do you really think so? Let's ask HR if they're willing to sign a document so that I can ask their medical health provider. No, they have no right to speak to your treating healthcare provider about anything. All you need is a letter saying this is the condition and these are the limitations. That's all you need. Don't fill out any forms. Step 3, a conversation begins with HR, the faculty member, and the provost's office. And again, the first time you do this, you have no idea what that is. So please, I would encourage you to involve the IFO so that you have people going through there. The faculty member may choose to have an IFO representation or a representative. It should be an interactive process. That's what it said. And HR should respond in a reasonable time to request for reasonable accommodations. One of the problems is currently it's not an interactive process. It's a I will tell you process. And there's no response to follow-up emails or follow-up conversations. That is not an interactive process. Time frame, 4 weeks maybe, but not 2 months. Not 2 months, absolutely not. Notification. Your dean and the department chair will be notified as to the type of accommodation. HR cannot release any medical information to your supervisors or your coworkers without your consent. Should not disclose your accommodation. They should not know what your condition is. They can see the accommodation, but they should know nothing about your condition. And people with non-visible disabilities are a little bit nervous about that, a little bit protective about certain amounts of information getting out. Access, again, ADI requires employees to keep medical information confidential and separate from the employee's standard personnel file. That's all well and good. That means your personnel files are here, your medical files are here, but anyone in the HR office can go and look in your file. That's problematic. Any of the workers that come and go there can have access to that information. If the condition is permanent, and the faculty member's need hasn't changed, HR cannot do what they did to me. They cannot request that you go through the process again. They cannot do that. If you ask for a change, if your condition has changed, then they can. But they cannot randomly say, well, we want you to go through this process again. Why? It could become weaponized, for one thing, and it's not necessary if your condition has not changed. The interactive process can continue if the employee needs change, if your condition changes, but it should be initiated by you and not by HR or administration or your supervisor or anyone else. And by the way, one of the things we're trying to do right now, ADA is in the HR office, and we're trying to get it into accessibility's resources because there seems to be a natural conflict with HR and employees. And I don't know why this is. It shouldn't be that way. We're on the same team. We want each employee to be able to do his or her job. We're not trying to get away with anything. But I think accessibility resources, I don't know if and when this will happen, are in better position to help us with the ADA. And by the way, I always hate requesting an accommodation because you're requesting your civil rights, your basic civil rights. We shouldn't have to request our basic civil rights. Two big ideas here. When a disability or need for accommodation is not obvious, HR may request reasonable medical documentation, all right? But you should never fill out any forms. They give you the impression that they're required, and they're not. Those are two very big ideas. All you need is a note or a letter from your medical health provider. This is the disability. These are the limitations. That's all that's needed. No forms are needed. You need to contact HR or your supervisor, but no forms are needed. Here are some very important sources. Any question, ADA, Great Lakes, they exist to answer your questions. Typo there. Minnesota Department of Human Rights. Now, federal regulations are sometimes different than the state. This is the federal, U.S., this is important. Here's the Job Accommodation Networks and the Minnesota Department of Human Rights. These are all very good resources. Here's the MMB. They have information there. And if you need to file a complaint, this is where you should start, at the state level versus the federal. They tend to be a little bit more responsive at the state level. And it gives you all the information there. And you can see the exact, the law related to the ADA at this site. You can see Governor Tim Walz's executive order, all right? And get an overview there. So that is a good resource to use, very good. And as I said, those forms that HR use, that is a statewide thing from the MMB. And I hope someday they will get those taken down because you need not fill out any forms.